Welcome to Oil and Gas Law with Energy Law Prof. Today we'll talk about typically the second clause in your average oil and gas lease, which is the Habendum clause. Now, you may remember from your first year criminal law class, habeas corpus means you have the body. Habendum clause means you have the lease. It's how long the lease lasts. Now, that Habendum clause is sometimes called the term clause because, again, it defines the term that the lease lasts for. Typically, it's very short, but it includes basically two terms. The primary term, which is how long you have to explore for oil and gas and drill your first producing well. And then the secondary term. And historically and typically, just like in the example lease I gave you, the secondary term just says that the lease lasts as long as oil and gas is produced. Now we'll see there's some subtleties in what it means to say oil and gas is still produced from a lease. We'll see that in later lessons. All right, so here's that typical Habendum clause. As you can see, it's very short. Subject to the other provisions herein contained, this lease shall be for a term of 3 years, 4 years, 5 years from this date. That's called the primary term, and as long thereafter as oil and gas or other minerals are produced from said land or land with which said land is pooled hereunder. Okay, so what are the big problems under the Habendum clause? First problem, which we'll explore today, is maintaining the lease during the primary term, that initial period where the oil and gas company has the exclusive option to drill for oil and gas. Then, what does it take to propel the lease into the secondary term? So, to have production from the lease, that means the lease is producing oil and gas, and you can keep it as long as oil and gas is produced. And we'll see there are subtleties in defining what counts as production from the lease. And we'll see that typically courts define it as you need to have production at least in paying quantities. And sometimes even if you don't literally have production, there are other things that under the lease are construed as production. We call them production even though it's not literal production. So we call that constructive production. Okay, so today we're talking about the primary term. Now, in the primary term, one of the big challenges to maintaining the lease is paying drilling delay rentals. Now, we'll see that these drilling delay rentals weren't really initially part of the lease. They were kind of made up by the courts, or they were made in response to implied duties that the courts kind of made up that weren't really in the lease. So the idea of the drilling delay rental is it provides the landowner with a small payment, a drilling delay rental, in return for not drilling. The reason that these developed is to disclaim any implied covenant to test. Now, the implied covenant to test was an implied promise that was basically made up by the courts. Now, you know the basic structure of an oil and gas lease. You have that initial primary term, 3 years, 4 years, 5 years, 10 years to drill. Courts didn't really like that because they said, well, you know what? I mean, yes, you've given the landowner this bonus, and yes, if you eventually produce oil and gas, they will get that royalty. But you know what? It's kind of annoying that the oil and gas company is going to wait till the end of this primary term that they negotiated to drill for oil. And so they said, you know what? Oil and gas companies should be required to drill for oil within the first year, at least to test for oil, even if the primary term is longer, even if the primary term that they negotiated is 10 years. Okay, this is a little bit funny. It's not the normal way that we negotiate, that we in courts construe contracts nowadays, where they focus on the text of the contract. This is basically made up because courts felt that the deal that the landowner had agreed to, where there was a 10-year option to drill for oil and gas, was unfair to the landowner. So they made up a new term which said oil and gas companies, you have to drill that first well to test for oil and gas within a year. Oil and gas companies didn't like that. The whole reason they negotiated a longer primary term was because they wanted to have a longer period where they just had the option to drill. And so to respond to those court decisions, what they did was they said, you know what, landowner, look, I'm not going to drill in the first year. We agreed to a 10-year term, but since the courts want me to test for oil and gas within a year, you know what, instead of doing that, I am going to pay you a delay rental that makes up for my failure to drill in the first year, like the courts wanted me to. Okay, so there's a couple different kinds of drilling delay rental clauses that were used by oil and gas companies in response to these court decisions. Probably the most common type, and we're going to see a bunch of cases about it, was the unless rental clause, which basically said, unless I pay you a drilling delay rental or drill within the first year, the lease is going to expire. And under this, there's no obligation to drill for oil, and there's no obligation to pay a rental. But if you don't do either, the lease will terminate. There'll be automatic termination if you don't drill within the first year and you don't make a payment. All right, let's talk about a case about an unless rental clause. Schwartzenberger versus Hunt. It's a North Dakota 1976 case, page 202. There's a lease. It's taken in 1972. The Hunt estate paid the delay rentals for the first 2 years. Okay, so they're paying their delay rentals just as they should to extend that primary term through the full primary term. What's the problem? Well, there was a mistake. Both Schwartzenberger and the Hunt estate thought that there was a little bit smaller acreage than it in fact was, and so the payments were $8 short. This is an unless drilling delay rental clause. Here's what an unless drilling delay rental clause looks. It's very similar to the one in your example lease. If operations for drilling are not commenced on or before 1 year from the date hereof, the lease shall terminate unless on or before such anniversary the lessee shall pay or tender to the lessor or the credit of the lessor at the bank X dollars, herein called rentals, which shall cover the privilege of deferring commencement of drilling operations for a period of 12 months. Upon like payment annually, the commencement of drilling operations may be further delayed for successive periods of 12 months each during the primary term hereof. Okay, so unless the payment is made or you have drilling in that first year, the lease will expire. Okay, the court here says that because the payments were $8 short, the lease expired. Why does the court say that? Well, there may be a couple reasons, but basically it seems that the court believes that Hunt acted negligently in the land work. So yeah, it was a mutual mistake between the landowner and Hunt about exactly how many acres there were, but the court seems to think, well, really, Hunt should have known. They should have been looking more carefully. They're the land experts. They should have realized that they were $8 short. And also, Hunt was eventually notified by Schwartzenberger that they owed $8 more. And instead of just paying the $8 right away, they ignored the Schwartzenberger. So we get this seemingly pretty harsh result, which is you paid a bunch of money for this lease, for the option to drill, for 10 years, and you lose it because you were $8 short in your rental payments. Really what happened here, it seems that the landman for Hunt made an error. The landman, the one that actually goes through the title record to see who has the property. It turns out Schwartzenberger's actually had a little bit more acreage than they thought, because although they only had 95% of the minerals in most of the property, they had 100% of the minerals in 1/4. The landmen wrongly assumed that they owned 95% throughout all of it, and so the delay rentals were a little bit short. Now you notice an in-gross clause that we talked about in the last lesson might have protected the Hunt here. Okay, so the court holds the lease terminates because the unless delay rental clause says you have automatic termination if the delay rentals aren't paid. Okay, so you got to pay your delay rentals properly. What does that mean? Well, it means you have to pay them on or before the due date. It means you have to pay them at least the amount provided for. It can't be $8 short. It means you have to pay the proper parties. You'll notice that the lease says you can send it to the landowner directly, or you can just send it to their credit at the bank, so there can't be any dispute about whether they got it or not, and it has to be in a permitted manner. Typically, one of the options will be paying it to the credit at the bank. All right, so a couple things. One is, obviously, the dire consequences of losing this lease that you may have paid hundreds of thousands of dollars for because you were $8 short in a payment means that oil and gas companies take their obligation to pay delay rentals very, very seriously, and they make sure to track them, and if they don't, they are in serious jeopardy. Also, why would any oil and gas company agree to an unless delay rental clause, where if they fail to make a payment, they lose the lease? What possible advantage could there be to this kind of lease structure? Well, it's not clear to me that actually it is an advantage overall, but I mean, one benefit of it is it basically allows you to more or less ghost your landowner. And if you do, the lease will just end. So you don't have to pay them any money. You don't have to drill. The lease simply ends when you lost interest in it. And as we'll see, as long as the lease continues, the oil and gas company has some continuing duties to the landowner, and this basically cuts them off. So, maybe no mess, no fuss way to end the lease. Okay, the other option that's typically used is an or rental clause. An or rental clause says, the lease doesn't automatically terminate. You just have an obligation as the oil and gas company to either drill or pay. So if you don't drill, then you have the obligation to pay, and you can be sued for those delay rentals. So unlike an unless clause that doesn't create an obligation to pay, but just cuts off the lease, allows you to just ghost it, and then both of you are done with that legal relationship, an or rental clause says, no, if you fail to drill, you have an obligation to pay me. So we would say that that is a covenant, not a condition or special limitation. Now this language will show up again in a later lesson, so I want you to pay a little attention to it. So covenant is a promise to pay some money, that obligation to pay that's under the or clause. And unless clause, which says the lease cuts off if you don't pay it, that's a condition on the continuance of the lease. So the unless clause is often talked about as a condition that will end the lease if you don't make it, and a or clause is often talked about as a covenant. If you don't drill, you promise or covenant to pay those drilling delay rentals. So the lessor in this case doesn't get out of the lease, it just has the right to sue for rentals plus interest. Okay, the or rental clause typically will also include some kind of forfeiture clause that says, look, yeah, you don't immediately forfeit the lease if you fail to pay rentals, but if it's a long enough period of time and you've been notified that you failed to pay rentals, eventually you're gonna forfeit the lease. So, if you ghost your landowner for long enough, yes, that lease will end as well. Here's an example or lease forfeiture clause. If any rental or royalty not paid when due, the lessor shall notify the lessee thereof in writing, and the lease won't terminate unless the lessee fails to make such payment within 15 days after receipt of such notice, provided, however, that if there's a dispute as to the amount due and all undisputed amounts are paid, the 15-day period shall be extended until 5 days after such dispute is settled by final court decree, arbitration, or agreement. If the lessee fails to make such payment after receipt of such notice, then the lease shall terminate. Okay, so basically this forfeiture clause says, yeah, it's not going to end immediately because you don't make rental payments, but if the landowner notifies you, hey, where's my rental, and you don't respond for 15 days after you got it, then the lease will terminate. Okay, hybrid rental clause. You can have an unless clause, which would terminate the lease with some kind of savings language that says, look, if I just made a mistake or if it hasn't been that long, the lease should continue. So here's an example from a Colorado lease. If drilling operations aren't commenced on or before blank, the lease shall terminate unless the lessee makes a payment. But if the lessee shall in good faith and with reasonable diligence attempt to pay any rental, but fails to pay or incorrectly pays part of the rental, the lease will not terminate unless lessee fails to rectify the error within 30 days after written notice of the failure. So if I tried to pay the delay rentals, I just made a mistake, then let me know and I get 30 days to fix it. Okay. You might think that all of this delay rental business is just too complicated. The whole point of the lease was to have some period of time where you just had the option to drill. And if that's how you feel, then you probably want to explore a paid up lease, which basically just says, look, can't I just pay all these rentals ahead of time and then wait on to drill through the full primary term. And that's the intent of a paid up lease. And just a lease with no rental clause, the idea is, you know what, we're just including all the rentals we would have paid you in the bonus. Here's how a paid up lease would look. This is a paid up lease. In consideration of the down payment, the lessor agrees that the lessee, the oil and gas company, won't be obligated except as otherwise provided herein to commence or continue any operations during the primary term or to make any rental payments during the primary term. So this has kind of got us back to the start, and courts now will allow you to do this. So nowadays, most commonly, oil and gas companies are going to want a paid up lease where they don't have to bother about delay rentals during the primary term, and they can just wait till the end of the primary term to drill. Okay, so oil and gas companies have till the end of the primary term to drill. What does it mean to commence drilling that is going to allow the lease to continue? Typically, there's going to have to be some activity on the land or nearby land that's directly related to preparation for actual drilling. Now, typically, you won't have to have the drill bit actually enter the earth to say that you've started drilling on the land. Commencement can be defined by the lease to include whatever you want, including spudding, which is the drill bit actually entering the land. But if the lease doesn't say that, then typically you just need some activity related to drilling operations. Here's an example case. Breaux versus Apache Oil. It's a Louisiana case from 1970, page 219 in your books. Okay. Lessor says the lessee didn't commence the well in the time specified in the primary term of the lease. What does the lease say? Well, the lease says it's going to terminate unless on or before the date the lessee commences operations for drilling of a well on the land or acreage pooled therewith. All right. So what are typically the starting stages of drilling? Well, you're going to need to have a drilling rig. Here's kind of what you're going to do. One is you're going to include a wide conductor pipe that's going to separate the land from the pipe and the drilling that you're doing. That's going to keep dirt out of the hole. It's going to be your largest pipe. And then you're going to have some surface casing that's drilled to isolate the groundwater zone. And typically, you're going to use just water-based drilling fluids while you're in that groundwater zone. Typically, you have to use that surface casing until you get about 100 feet below the base of the groundwater. Okay. Now, how the drill bit works, I'd encourage you to go to the Breaux Museum if you're in Dallas to check out how a drill bit works. But basically, you can see it on the left here, which is that you have this drill bit that is basically crushing up the rock, and then you're sending mud down the drill bit that pushes those rock shavings back up to the surface so that they don't get in the way of the drill bit. And that's what allows us to drill, a mile under the earth or 2 miles under the earth, and then a mile, 2 miles, 3 miles laterally. That is the technology that we're using. So in this case, the Apache Oil Corp doesn't actually get to there. The question that the court is considering is whether drilling operations had commenced, and all Apache Oil has done at this point is built a board road and a turnaround road to get the drilling rig in. There's a factual dispute about whether the drilling equipment had actually gotten present on the day of the expiration, and the drilling doesn't actually start until after the lease expired. But the court says, you know what? Building the road is enough. Actual drilling not required. And as I said, this is kind of the typical majority rule. Now, there are minority constructions of commencement. Remember, we're talking about here kind of what's the default if the lease doesn't specify. In Montana, the court said that in this case that spudding is required, so the drill bit has to actually enter the ground. In Kansas, they have a requirement not that spudding is necessary, but that the lessee has to have a drilling rig or have one under contract. Because sometimes, really, if you don't have that drilling rig, you built your turnaround road and your board road, but if you don't have access to a drilling rig, it might be a while before you're able to actually drill as required by the lease. Okay, one final issue that has grown more prominent recently is what happens if you're not actually going to do any preparations for drilling on the lease itself. You're going to do it on a neighboring lease because you intend to drill horizontally. The United States, as we talked about earlier, they use a leasing structure that's actually very similar to what a private landowner would use, but you can see here that it has a provision for commencement of drilling where it happens on a neighboring property. So here it is, section 11, directional drilling. Directional well drilled under the leased area from a surface location on nearby land not covered by the lease shall be deemed to have the same effect for all purposes of the lease as a well drilled from a surface location on the leased area. Drilling shall be considered to have been commenced on the lease area when drilling is commenced on the nearby land for purposes of directionally drilling under the leased area. So what this U.S. offshore lease is saying is your drilling has commenced within the primary term if you drilled on a neighboring property with the intent to drill laterally under this property for production.